And last time I also remember having told you that you don't need to, I will not be able to explain the alteration of memorandum in class, but you are free to read it from the book. That's what I had mentioned. And again, alteration of articles, just to mention it briefly, every company can alter its articles whenever it desires by passing a special resolution and filing a copy of altered articles with the registrar of companies. But look at this, in case of a conversion of public company into a private company, alteration in the articles would only be effective after approval of the central government, and this power of central government is now vested with the registrar of companies. So, do you remember public companies and private companies, the key differences that we discussed, right? And if because of this, your public company, let us say you had you are meeting the requirements of public company, and if because of this change, let us say all the shares are now getting concentrated in the hands of one or few shareholders, and it becoming a private company, even that is okay, but it should be effective only after approval of the central government is received. And look at the last two lines. All clauses in articles which are ultra vires the memorandum shall be null and void, and articles shall be held inoperative in such case. Right? And so that's the other part that we have to consider. But alteration of the articles shall not violate 1. Companies Act or any of its provisions, and 2. The memorandum of association. Because articles of association is subordinate to the memorandum. Articles of association is subordinate to the memorandum. Next. So this we have just discussed. It can't be against the Companies Act. Alteration cannot be inconsistent with the memorandum, and it can't be inconsistent with any alteration ordered by the National Company Law Tribunal. So NCLT is a body that has been set up post the 2013 Companies Act. And in the good old days, for example, if you have to ask for merger of companies, you would have to go to the High Court of your state, where the registered office of the company is situated. You have to get approval from the High Court of that state. If they are in two separate states, you need approval of two different high courts. Right? But post 2013 Act, now they have said that instead of High Court, let this power be vested in the National Company Law Tribunal, which is called as NCLT, where you can anyways, if you have any dispute or any legal issue related to companies, you can also approach the NCLT for this. And it should not constitute a fraud on the minority by majority. It must be bona fide for the benefit of the company as a whole, and it should not be aimed at depriving any person of his or her right. So these are common sense. Right?